arbitrationagreements.org. Today I am here to shed light on an important aspect of dispute resolution that is gaining prominence day by day. I'm talking about grievance mediation procedures. Before we get started, please give this video a thumbs up, press the subscribe button, and hit the notification bell so you can stay up to date about important alternative dispute resolution topics, which can help you keep costs low. First things first, let's delve into what grievance mediation is. It's a voluntary and confidential process where a neutral third person, known as a mediator, assists the disputing parties to reach a mutually agreed solution. This procedure is quite informal compared to court proceedings and provides a platform for open dialogue. Now let me share with you some intriguing statistics that underscore the importance and effectiveness of grievance mediation. According to a recent study, about 8 to 9 out of 10 disputes that undergo mediation are resolved successfully. Furthermore, approximately 70 to 80% of parties who opted for mediation felt highly satisfied with the process. These stats are indeed promising and demonstrate the positive impact that mediation can have. The primary goal here is to facilitate communication between the parties, to help them understand each other's perspectives and find a resolution that caters to the interests of both parties. This process is quite dynamic and flexible, allowing for a wide array of resolutions that might not be available in a court setting. Moving on to the actual procedure, it generally follows a few essential steps. Initially, parties meet with the mediator individually to discuss their concerns. Then, a joint meeting is arranged where each party gets an opportunity to express their grievances openly. The mediator does not impose any decisions, but guides the conversation in a constructive direction, assisting in identifying possible solutions. I would also like to touch upon the role of the mediator. Being a neutral entity, the mediator does not have vested interests in the dispute's outcome. Their role is to facilitate dialogue, help identify common ground, and assist in drafting an agreement if a resolution is reached. The mediator possesses the skills to handle conflicts delicately and encourages parties to find common ground. Now you might be wondering about the duration of this process. Well, it varies greatly depending upon the complexity of the issue at hand. Some cases might be resolved in a couple of hours, while others may take a few sessions spanning several days. Also, let me emphasize that one of the most remarkable features of grievance mediation is the preservation of relationships. Since the process encourages open dialogue and understanding, it often results in more harmonious outcomes, allowing parties to maintain or rebuild their relationships, which is indeed a significant advantage over adversarial processes like litigation. If you want to learn more information about mediation, please visit arbitrationagreements.org. That is where you can purchase what you need to start the dispute resolution process in the correct fashion to handle issues online. Our association does not provide legal advice, but many people from multiple industries use our services to navigate claims in a controlled manner through a cost-effective framework. If you're interested in doing that, give us a call. Also, what do you think about mediation? Which advantage of mediating a dispute is your favorite? Drop a comment below and let us know your opinion. Please do not forget to give this video a thumbs up, subscribe to our channel, and hit the notification bell so you can receive the latest updates about dispute resolution that can help your business succeed.